You brought this case before the court. What's going on?
Yes, Your Honor. When last we met, had my 3 children with my wife.
Yeah, I remember that.
Yes, ma'am. The 12-year-old is now 13 and has come to live with me. So
Okay.
I'd like to see if there's any possibility of getting my child support reduced since she's with me now.
Okay, the cheerleader, right?
Yes.
Okay, I have a good memory sometimes.
Welcome back to Judge Bench, where real cases reveal real consequences. If you're new here, hit that subscribe button and join us as we unpack the powerful courtroom moments that shape families, finances, and futures. Today, we're revisiting the case of Mr. Shepard, a father returning to court, seeking a modification in his child support obligation. You may recall Mr. Shepard from a previous episode, where he was paying support for all 3 of his children, but things have changed. Since then, one of his children, his 13-year-old daughter, the cheerleader, as the judge fondly remembered, has come to live with him full-time. And that change of custody brought him back to the courtroom. Mr. Shepard opened by explaining to the judge that, beginning around December or January, his daughter had transitioned into his household. That's approximately 4 months of cohabitation at the time of the hearing. When asked whether this arrangement had been agreed upon, he clarified that it was something that developed over time, not a sudden shift, but a mutual decision between him and his ex-wife.
Where is your ex-wife?
Where?
Yeah, she's not here.
I wish I could tell you. I wish I could tell you. I thought she was going to be here.
I mean,
Talked to her on the
thought she
phone
would've been
2-3 days ago, and I thought she was good to go.
Well, I thought she was good to go too because it looks like she was given notice to be here,
Yes, ma'am.
and she came the last time.
Yes, Your Honor. She sure did.
Okay.
But here's where it got a little more complicated. Mr. Shepard's ex-wife, the children's mother, was nowhere to be found. She had attended the last hearing, and Mr. Shepard had even spoken with her just a few days prior, expecting her presence in court. However, despite being properly notified, she did not appear, and that detail played a critical role in how the case proceeded. The judge, clearly surprised by the mother's absence, given her vocal stance at their last hearing, acknowledged that the court had given proper notice. And when someone who has been legally served fails to appear, the court is within its rights to move forward without them. And that's exactly what happened. So what was Mr. Shepard asking for? Simply put, a reduction in his child support payments, given that one of the children now lived with him full-time. And the judge agreed, but not without careful calculation. Mr. Shepard had already been paying for health insurance to the tune of $503 a month. The court had previously taken that into account by setting his support obligation not based on his income, but based on the cost of tuition. That's a rare deviation, but in this case, it had already been granted.
So there isn't a dispute between you two of whether or not the child has been living with you, or how long has the child been living with you?
About, let's see, December, January, 4 months.
Okay.
Yeah, we made it the middle of the school year.
Okay. And is that something you guys agreed to do, or is that, did something happen and the child started living with you?
Roughly, we agreed to it over a little bit of time.
Okay. Well, I'm guessing that's why she didn't come.
With the new development, however, the court adjusted again. Mr. Shepard still has 2 children living with their mother, but now that one child resides with him, he is entitled to credit for that. And with that credit applied, his monthly child support was reduced from $2,400 to $1,098. That's a significant difference, nearly $1,300 less every month. When the judge read the new figure aloud, Mr. Shepard expressed his appreciation. There were no objections, no confusion, no argument. Just relief, a fair adjustment made based on changing realities, and made possible because he showed up, made his case, and had the documentation to support it.
Because she didn't have any opposition to it, but that's neither here nor there.
I thought she'd have something to say.
Well,
But
yeah, because she had a lot to say the last time we were here.
yes, ma'am. Surprise, surprise.
Okay. Well, this is what we can do. She's not here, so we can move forward with your case. From what I remember, and okay, your health insurance documents, you pay $503.
$503, yes, ma'am.
For the health insurance,
Yes,
okay.
Your Honor.
And I remember what we did was, instead of making you pay child support based on what your income was, we set it at the amount of the price of tuition for all three
Tuition,
kids.
yes, ma'am.
Okay, so you still have the obligation of the other two children, obviously.
Yes, Your Honor.
Now, this case highlights two key takeaways for anyone involved in child support matters. First, if your household circumstances change, especially something as substantial as a child coming to live with you full-time, you absolutely have grounds to request a modification, but you must do it through the court. Informal agreements, verbal understandings, and assumptions won't protect you legally. File the paperwork, attend your hearing, and present your case clearly. Second, attendance matters. The mother in this case had been properly served and still chose not to appear. Her absence didn't stop the legal process. Courts operate on evidence and presence. When you fail to show up after being notified, you're not only forfeiting your chance to speak, you're giving up control over the outcome. The judge even commented on the prior deviation and noting that Mr. Shepherd had already been paying less than the typical guideline amount. That's a reminder that every case is unique. Judges don't just blindly apply numbers. They listen, they remember, and they apply the law with both fairness and practicality.
But we're going to give you credit for one of the children living with you. So slightly coming off that $2,400 amount, your child support will go down to $1,098.
I'm sorry.
$1,098.
$1,098?
$1,098, yes.
Yes, Your Honor.
Yeah.
Sounds great.
Okay. So, do you have any other questions?
I don't think I better.
Okay. Yeah, because last time we deviated and it was a lot lower than what it should have been.
Yes, Your Honor.
Okay. If there's nothing further, you're dismissed.
Thank you, Your Honor.
You're welcome.
In the end, justice was served in this courtroom. Mr. Shepherd walked away with a more manageable support, obligation, and more importantly, he stood up for his rights as a father. His case serves as a powerful example of how to navigate the system responsibly and effectively, and how showing up, staying respectful, and providing the right evidence can change everything. That's it for today's breakdown. If you found this case insightful, or if you're learning something new about the child support system, make sure you hit that like button. And don't forget to subscribe to Judge Bench for more real-life courtroom stories, analyzed with clarity and care. Until next time, stay informed, stay empowered, and always remember, justice doesn't just happen. You have to show up for it.